All right, members of the jury, we are continuing with the evidence in this case. And let me just remind you once again, please not to have any contact or communication with this case outside of court. Mr. Baez.
May it please the court. Mr. Hagan. Good afternoon, ladies and gentlemen.
Good afternoon.
Mr. Bradley, I want to tie up a couple of things before we conclude. First of all, do you remember the questions that we referenced in regards to Jamar Durham?
Yes.
Okay. I'm going to show you a police report. I'd like for you to review it and see if this refreshes your recollection as to Mr. Durham. Okay?
Okay.
May I approach the witness, Judge?
You may.
Take your time to observe it and read the report and its contents. front, can you just let me know whenever you're complete?
I'm almost done. I'm done. This is not accurate.
Sorry?
That's not accurate about me.
Sir, if you would, wait for a question.
Oh, I'm sorry.
Having reviewed that, put the question.
Yes, sir. Having reviewed this police report, does that refresh your recollection that you do in fact know Jamar Durham?
No, it doesn't.
Sir, you testified to the jury that after the shooting on July 16, 2012, that you never used the Toyota 4Runner again. Do you recall that testimony?
Yes, I believe I do.
Okay. And do you recall giving a statement in your proffer, one where you got the deal, when asked, did you ever, page 97, counsel, lines 13, did you ever see the car again after that night? And do you recall giving the answer? Yeah, to be honest, I may have even driven it after, because what's throwing me off is the fact that I know that they came to the stadium and asked for the car. At some point, it must have been, back out, and I think that's when he dropped it off over there and put it in the garage. I mean, I wasn't with him, but when he did it, that's what would have happened. That's where it was. Do you recall giving that statement, sir? That answer, sir?
No, I don't recall, but if that's what it says, then that's what I said.
Okay. And this, again, is a situation where your memory does not get better with time, right?
Overruled. You may answer that. Thank you.
I guess in this instance, that would be correct.
Okay. Now, I'd like to mark the text that we referred before lunch as an exhibit, Your Honor.
Are you offering that as an exhibit?
Yes, sir.
Is there an objection?
Subject to redactions, Your
Uh,
Honor.
We have an agreement to just...
All right, if there's an agreement as to redaction, then it is received, subject to that redaction.
Okay, sir, Mr. Bradley, you recall this text message that we reviewed before we went to lunch?
Yes, I do.
Okay. And this was a text message sent to your lawyer?
Correct.
Okay. And in this text message, you state the following. Now, you're sure once I withdraw this lawsuit that I won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me? My question to you, sir, is do you see the date that it is sent?
Yes.
Okay, and that's July 5th, 2013 at 12:28 in the afternoon?
Correct.
Okay. Now, do you recall I'm now showing Exhibit 301, which is your deal with the Commonwealth.
Yes, I do.
Okay, remember when we first began talking, I went over this line by line with you.
Yes.
Okay, and do you remember the section where it says, if the district attorney learns that the information or testimony that Mr. Bradley provides after the date of this letter is not complete and truthful, then the district attorney may declare this agreement null and void. Should the district attorney declare this agreement null and void because the information or testimony provided by Mr. Bradley is not complete and truthful, the district attorney may institute a prosecution of perjury. You see that, sir?
Yes, I do.
Okay, and you understand all of that, right?
Yes, I do.
Okay, now, you gave you sent that text message July of 2013. You recall that?
Correct.
You signed this document on September 10th, 2014.
Correct.
Okay, and in between September 10th, 2014 until now, has the district attorney informed you that they have decided to declare your agreement null and void?
No, they haven't.
Okay. Did you get any bad news at lunch?
No, I did not.
Okay. Aside from the bologna sandwich, nothing negative happened.
Sustained.
If I can have just one moment, Judge. I have no further questions.
Mr. Hagan.
Good afternoon, Mr. Bradley.
Good afternoon, Mr. Hagan.
Just want to clarify some of the questions that were asked on cross-examination. Let's start with what Mr. Baez just left off with, the text message between you and your lawyer sent on July 5th, 2013. I'm just going to place a portion of that on the screen. I believe it's now Exhibit 311, subject to redaction. In addition to that text, Mr. Bradley, is there also a text above that relative to a grand jury proceeding? Can you just read that text?
And last but not least, my license are suspended. I need an eye procedure, and me being scared for my life isn't enough for me to get out of testifying to the grand jury.
And when you sent these texts to your lawyer, Mr. Pickering, in July of 2013, had you already been subpoenaed to testify in a grand jury in another county in Massachusetts?
Yes, I believe so.
Maybe
Yep.